A buyer has a duty to take delivery, and that means doing all of the acts that would be required, that could be expected to enable the seller to make delivery. So taking delivery is more than simply accepting delivery of the goods. It means doing whatever is necessary in order to permit delivery to take place. Speaking of delivery, what happens on delivery? Well, the buyer now has an obligation. Once the goods are placed in his hands, the buyer has an obligation to inspect the goods, and the buyer has an obligation to notify the seller if there is any non-conformity in the goods. So there's actually two things that a buyer must do upon taking delivery. The buyer has an obligation to inspect the goods, and the buyer has an obligation to notify the seller of any non-conformity in the goods. Now the CISG makes these periods, inspection and notice, those periods are held to be separate periods, even if it may seem more logical to combine them. But the CISG treats those as separate periods under the contract. Now, the buyer's obligation to examine the goods begins on delivery, regardless of when the goods are intended to be used in business. It is delivery that triggers the inspection period. So on delivery, buyer must inspect, regardless of whether the buyer intends to use the goods immediately or at some far off point in the future. Now, after the period for examination closes, and that period is basically going to be a reasonable period. What would be a reasonable period under the circumstances? After the period for examination closes, then the period of timely notice begins. Goods are presumed to be accepted if the buyer does not give notice within a reasonable time. No fixed period is going to constitute reasonable. It's going to depend on the particulars of the particular contract. Now, if a buyer fails to give timely and proper notice, then the buyer will lose the right to breach, to sue the seller for breach of the contract. The buyer cannot assert the seller's breach if the buyer has failed to notify the seller of the nonconformity. The reason why, we'll see when we get to remedies, is that a seller has a right to fix the problem. We call that the right of cure. The seller has a right to cure the problem, and if that seller fails to get timely notice, then the seller's right to cure the problem is jeopardized. Therefore, if that is the case, the law holds that it's more fair for the buyer to deal with the breach than it is for the seller. Now, this notice of nonconformity should be specific as possible. Explain why it is that the goods do not meet the type of quality or quantity as specified in the contract. And the reason, again, for this specificity requirement is that the seller has a right to cure. And the seller is much more likely to cure if the seller knows exactly what is wrong with the shipment of goods. Let's look at a case in your book. My case is Chicago Prime Packers versus Northam Food Trading Company. Now in that case, Chicago Prime is a meat wholesaler. Chicago Prime contracts with Northam, who is a Canadian corporation, for the sale of certain pork ribs. Now Chicago Prime transferred the ribs, the pork ribs, to a shipping company hired by Northam, the Canadian company. Now, ultimately, when the ribs arrived in Canada, they were discovered to have spoiled in transit, despite the fact that the ribs should have been okay when they were shipped. The ribs were placed in refrigerated transportation for the entire time of the trip, Nevertheless, when they arrived in Canada, the ships were spoiled. Now, there's no contract clause regarding inspection, so the court in this case said that the CISG applies. And the court also said the CISG contains an obligation to inspect as early as possible. The CISG also says that a party has an obligation to give notice as early as possible as well. And there is a link between the time to inspect and the time to give notice of the nonconformity. Now, in this case, the court found that the Canadian company had not conducted inspection within a rapid response time and failed to give notice in a fast enough time once they discovered the spoiled pork ribs. So the lesson of this case is that there are two periods: inspection period, notice period, and in both those cases there's an obligation to act quickly and efficiently.